Jefferson County Court of Law number 2 is in session. The court is in session. And calls number 25 CCCR 1333A, case of style state of Texas versus Brandon K. Howard. Mr. Howard, would you please come forward? Your name is Brandon K. Howard.
Yes, sir.
How are you doing?
Pretty good.
That's good. Now, you're representing your case by your attorney, right, Kimler. Attorney Kimler is currently next door in the criminal district court. So he's tied up right now. But I've been informed from the state, and this is Ms. Farrah Nixon. She's a prosecutor for the state. She has informed me that they are dismissing your case. I have signed the dismissal. You can get a copy of this dismissal from our court coordinator. Once you get a copy of the dismissal from the court coordinator, you'll be free to go. And you have a blessed day.
Thank you so much.
Okay, and I see that you're here. You're not here alone, right?
No, my grandmother.
You're here with your grandmother, and I think she's been here
Every time.
every time.
Mhm.
Okay, now how old are you?
26, gonna be 26.
Okay, you look a lot young for your age. You look younger than 26.
Mhm.
But anyway, now your grandmother, now I know you being a young man, you have a lot of friends. I think these days y'all call them your BFF or your ride or die.
Yeah.
In my day, we used to call them our ace spoon coon.
Oh.
Okay. And you know, those was in the, you can stand right there. Those was people that we thought that would be with us through thick and thin. When we're down and out, they'll be there to pick us up, right? And so, but on days like today, excuse me,
My grandmother
The
used
per-
to basically.
who she is,
Yeah.
well, that's a good thing. Because I tell young people, everybody's not your friend, everybody's not your partner.
Mhm.
But when your grandmother says she got you, she got you. Okay? And so you're blessed. Some people don't have anybody.
Yeah.
You know, have a mother, father, grandmother, nobody. But you are blessed to have somebody that you call grandmother, and she's here with you today. And she's here because she loves you.
Mhm.
Okay? So I know this is not the proudest day in her life to see you in court all these days that she came in. She wasn't proud of that fact.
Mhm.
But today your case has been dismissed. And I've said that to say this. Anything that you want to accomplish in life, I know you have goals, you have dreams, and there are things that you want to do. This is not going to stop you. Okay? So just hold on, continue to hold on to your dream. And somebody, somebody might look at this on YouTube or even in person and might think, this guy's in a storm. You might have thought that at one point you were in a storm, because I know when you found out your case was dismissed, you was shouting for joy. Okay. And I've said that to say this. See, a lot of times in life we have ups and downs, we have trials and tribulations. Every day is not sunshine. We have some rain and some storms in our life. But remember this, when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. There's one thing about hope. Hope floats. So when you're drowning in the sea of confusion, you can't get it right. You're just confused about things. Just hold on to hope, because hope floats. Okay. So your case has been dismissed. You probably can talk to your attorney about getting it removed off of your record, because your attorney is quite competent in those matters. Okay. So congratulations. And ma'am, stay with him. Don't hang up on him. Hang on. All right.
Thank y'all. You just don't know what type of opportunity y'all have gained. He's been in college for 2 years now for criminal justice.
Great.
And he just got accepted in the police academy.
Man, congratulations.
Mm.
Okay. Just keep up the good, keep on keeping on, like people used to say, keep up the good work. Okay.
Mm. Thank
And
you.
that you made that lady a proud grandmama. Okay.
Yeah, investigate.
Okay. Continue to just continue. Hey, no, that she's proud. Hey, yeah. You just keep dreaming and keep reaching. Okay? Don't be ashamed of that. Yeah, don't be ashamed of following your dreams.
Yeah.
Okay? Just keep dreaming and keep reaching. Somebody say, shoot for the stars. If you miss, or shoot for the moon. If you miss, you're gonna be amongst the stars. Okay? So just don't let nobody tell you what you can't do. Because if you put your mind to it, you can do anything that you want to do. If you believe, you can achieve.
Mhm.
Your attitude determines your altitude, how high you go. Okay? So stay positive.
Yes, sir.
Okay? You know, are you familiar with Zydeco music?
Oh, yeah.
You heard Keith Frank say, you got haters?
Oh, yeah.
We all got haters. Okay. But but you're greater than your haters.
Mhm.
Remember that. Okay.
Okay.
All right. You have a blessed day. Now keep putting a smile on that before you leave here or before the day, before the sun go down today. You need to give that woman a big hug and a kiss.
Of course.
Okay?
Yeah.
For being here with you. All right.
Yeah.
All
Thank
right.
you so much.
You're welcome. Stay blessed.
y'all.
All right.
You're welcome. Bye.
Shit.
Probably want to get a number along with you. Okay, what do you say? Okay.
And Hussey? Hussey.
That's it.
Okay, Mr. Hussey,
Yes.
you're gonna go to that first row of chairs and go all the way to that first chair on the end down there.
Thank you.
Powers, you're gonna stand, you're gonna sit next to Mr. Hussey.
Barnett. 4,
Eves, you'll sit next to Ms. Powers.
Jacob.
Barnett, sit next to Mr. Eves. LaForte, you'll sit next to Mr.
Hey there,
Barrett. Is that Barrett?
Barnett.
Barnett.
you're number 6. Wilson. 6.
Ebert.
Yes.
Ms. Hebert,
Martinez.
Hebert, you sit next to Mr. LaForte.
Cantor.
And Ms. Wilkins, you sit next to Ms. Hebert.
Victoria.
Mr. Munoz,
Yes, sir.
you're gonna sit in that first chair and the second row of chairs. And Mr. Kenter, you'll sit next to him.
Victorian is here, Judge.
There's a Victorian is here.
Yes.
Okay, you're gonna sit in that chair that has the white paper in it. You can take the paper off. You can flip it back.
I'm sorry, that's Miss Victoria.
Yes. 10 is here. Maines,
D.
you'll sit next to Miss Victoria. Yes. Mr.
13.
Ms. Fitz, you'll sit next to Mr. Maines. Bean, you'll sit next to Ms. Fitz. Right there.
15.
Ms. Jacko, you'll sit next to Mr.
Landry.
Bean, right there, and Miss, that's Scruggs. You're gonna go down there, all the way down to the end, that first chair.
Roger.
Mr. Bolton, you'll follow and sit next to Miss Scruggs. Mr. Landry, you'll follow Mr. Bolton. And there's a seat in between. Yes,
Lebrano.
is that a roadshow?
Yes, sir.
You'll sit, there's a seat between you and Mr. Landry. And Mr. Madrano, you'll sit next to Miss Arocha. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. The felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the cases that we handle in this court are misdemeanor cases. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that normally start in the JP court, that's the Justice of the Peace, or the city court, which is the municipal court. Those cases come to this court when a person is convicted in one of those courts, and then they appeal their case. When they appeal their case, they get a whole new trial. We call it a trial de novo. And then once they get here, the punishment range stays the same. And the punishment range is a fine only. Just an example of Class C misdemeanors will be like a speeding ticket, not wearing your seatbelt, having an expired license tag. Those are Class C misdemeanors, but Class C misdemeanors are fine only, and the fine cannot be above or cannot exceed $500. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and jail time. And the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, a person may be eligible for probation. Now, you have been asked to come to court today to serve as a juror in this misdemeanor criminal case. The courtroom hours normally vary. They're usually from 9 to 5, 9 a.m. to 5 p.m. However, we start our trials at 1:30 because in the morning from 9 to usually 12 or 1, sometimes past 1:30, we have dockets. And this morning we had a jury trial docket, pretrial conference docket, and an announcement docket. All 3 of those dockets we had this morning. And when you combine them, you have somewhere in the neighborhood of in excess of 50 cases. Okay. Now, whether you're selected as a juror in this case, whether or not you're selected, you are performing a significant duty which only free people can perform. If selected, the case will be tried expeditiously, consistent, which require a careful and impartial, correct trial. If selected to serve on this jury, unless otherwise instructed, you will be permitted to separate yourself from recess, for meals, and at night. Now, at this time, I must administer to you the first of 2 administrative duties, and the administrative duties are administering to you oaths. So at this time, I need each and every one of you that's on the panel to raise your right hand. And once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Please say I do. Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications to serve as a juror on this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on the jury, the case could be retried and you may be held in contempt of court and placed in jail up to 180 days and fined up to $500. Now, the way I'm going to ask the questions to qualify you, I will ask a series of questions. I do not want you to answer those questions out aloud. Just answer the questions to yourself. And then once I finish asking the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I'm going to ask you to raise your hand. And once you raise your hand, we're going to ask that you will come before the bench so that we can discuss the matter more privately. And when I use the term more privately, what I'm talking about outside the presence of the other jurors. Currently, the trial is being aired on YouTube, and what we'll have to do, we'll turn off the YouTube. We have a noise sound device that sounds like this. And then I'll turn off the microphone, so you won't be able to hear the discussion. All right. So again, I'll ask a series of questions. Please do not answer those questions out aloud. Just answer it to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I would ask that you will raise your hand. Okay, so the first question in the series. Except for failure to register, are you a qualified voter in this county and the state under the Constitution and laws of this state? Second, have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause before I ask this next question, and I need to inform you that I'm required to ask this question by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County, Texas? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel is raising their right hand. Now I will proceed to exemptions. I will determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. Please answer the questions to yourself. Do not answer questions out loud. And once I finish, I would ask if there's anyone on the panel who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years? And jury service would necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3 years? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home station and out of your county of residence? Is there anyone on the panel who will be claiming an exemption? Let the record reflect that no one on the panel is claiming an exemption. I will now move to excuses. Now, with the excuses, I will not ask any questions. I will make 3 statements. And if you think that one of these statements apply to you, you would like to claim an excuse, I will ask, when I ask if there's anyone who would like to claim an excuse based on the 3 questions that I asked, then I'll ask you to raise your hand and you'll come forward. Now, the first statement, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state and without the consent of the defense. And this is the last statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, and all members of the jury is qualified at this time. Now, let the record reflect that the court has convened this case being cause number M331246, and the case is styled the state of Texas versus Dallas Clavel Jr. And ladies and gentlemen, you have been summoned to this court as prospective jurors in this criminal case. The defendant, Mr. Dallas Clavel, is sitting before you. He's in the middle, and to his left is his attorney. And Let me see. Okay. And his attorney is Attorney Jennifer DeLodge. And sitting to his right, sitting second chair, is Attorney Haley Simmons. The state is represented in this case by Attorney Cornelius Williams, who's sitting first chair,
Good afternoon. Thank you all for being.
and Attorney Farrah Nixon, who is sitting second chair.
Yeah.
Our bailiff in this case is, yeah, you met her earlier, Miss Mosby. And you met our court reporter. Well, you haven't met the court reporter, Mr. Sebastian Aguilar, and he's sitting in the jury box. The defendant in this case, Mr. Clavell Jr., Dallas Clavell Jr., is charged by information with the Class B misdemeanor offense of theft. And as I mentioned to you, the punishment range for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, a fine that does not exceed $2,000, or he could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of a panel, just say so, and I will ask that you will come up to the bench so that we may discuss the matter more privately. State, are you ready?
State is ready, Your Honor.
Okay, defense, are you ready?
Vince is ready, Your Honor.
Okay, and Mr. Williams, the panel is yours. Is 30 minutes enough?
30 minutes should be sufficient, Your Honor. Thank you.
Okay, you're welcome. And I'll keep the time.
Thank you, Your Honor.
You're welcome.
Justice is a divine concept given to us in the form of laws so that we can all get along with each other. During this period of WADA, all that we ask doing for some of these ground rules is to take the time and to answer our questions. Simply means, you know, you guys going to participate, but it's French for simply telling the truth. There's no wrong or right answers in this. During this process, all we want to see if you can be fair to Mr. Clavell as well as the state. How do we determine being fair? Just from listening to the evidence and then being able to present a verdict after that. And the way in which we look at the evidence is through our own common experiences. You know, we can do better. And what do I mean by we can do better? I can do better, but we can do better within our community, within our society. By doing better, you know, there was a book that was written quite some time ago. All I really need to know, I learned in kindergarten. You know what? It's very true. When a judge just said that you all are qualified after asking you all those 3 categories of questions, you have all that you need. Because I submit to you all right now, while justice is a high concept, we can look at this from the basic concepts that we learned through our parents and what we learned in kindergarten. This is real simple. There's no special knowledge needed to be able to listen to evidence which is presented and then rendering a just verdict. What do? We share everything. You know, when, how many of us have, children? Anybody have like kids with other children? Okay, now how many of us were children? Right? We all were children. You know, when children, if God allows them to stay alive, we all grew up. And some, once again, these basic concepts, we know that we're supposed to play fair. And you know what? When we go through each of these, this is what the very notion of justice and fairness is about, right? We ought to play fair. We don't hit people. If you hit people, to those who have like children, that may be, younger, if you remember 10, 15 years or so ago, when it started with, color codes, a kid got red today. Oh, they're gonna give you a call. The kid in pre-K 3, pre-K 4, kindergarten, kids on yellow. Keep an eye on him, keep an eye on him. We don't get people. You know what? We also don't take things that don't belong to us. You know, once again, we learn these simple concepts through our parents, through growing up. Everything that we need, that you will all need to know, we learned in kindergarten. This is not insulting to tell you, but some of the most basic fundamental things for us to all get along within our community, within our society. We have rights and responsibilities to one another. We don't take things that are ours. Does anyone disagree with that concept? I think not. You know what, when you hurt someone, we also have to take accountability for the things that we do. When you hurt someone, you say, I'm sorry, and then you try to make amends. It is no difference within our justice system. And you know what? We take responsibility for the things that we do, and we clean up our own mess. Viewing those fundamental concepts, what I submit to you, which I place before you, are the very notions and foundations of justice, so we can all get along. We would turn and we're going to apply within this matter, regarding the Sixth Amendment and the way in which we also view evidence. According to the Sixth Amendment of the United States Constitution as incorporated and accepted here within the great state of Texas, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. This is where we are. We're here. This is the public trial. By an impartial jury of the state and district where the crime shall have been committed. That's here in Jefferson County, and that's what we're doing with these questions, to look to see if you guys can be fair and impartial. He has the right to be informed against the nature and charges against him. He has the right to confront witnesses, and he has the right for compulsory process of obtaining witnesses. What does that mean? While the defendant has absolutely no burden, he can compel people to come in here to testify on his behalf as called by the power of subpoena. And he has the right to able counsel, which you also see sitting here before you. Now, as we still go through some of the preliminary matters, we need to determine if, some people may be testifying within this matter. And if you know them, will you be biased toward them? Or you may not like them. You'll be biased against them. Once again, we're just trying to determine if everyone can be fair and impartial. The first person is Christopher Robin of the Groves Police Department. First, he was a officer, detective, but now he is the city marshal over there in Groves. We expect him to testify. Does anybody know Christopher Robin? Sure. So that the record reflects, no hands were raised. That's a Chris Robin. Does anyone know Detective Richard Poss? Richard Chase Poss of the Grove with the Police Department. Does anyone know Richard Possoff had any dealing with him? By show of hands. Once again, for the record, no hands raised. We expect Ms. Tracy Meir to also testify. Now, she is the custodian of record at Market Basket headquarters down in Mid County, let's say Nederland. Does anyone know Ms. Tracy Meir? Once again, no hand. And we expect Mrs. Gloria Parker from Port Arthur to testify in this matter. Does anyone know Mrs. Gloria Parker? Does anyone know any of the able counsels for the defense? And we have this, let's see. Is that Ms. Fitz? Yes, Ms. Fitz. And who do you know on our wonderful defense side?
Don't know her name, but just see her out in public a lot.
Okay. She's involved in the community a lot.
Yes.
By Ms. Delage, being involved in the Mid-County community. By you knowing her and her involvement, would that affect the way in which you're able to judge the facts of this particular case? Thank you. Does anybody know Ms. Hayden Simmons? Yes, ma'am.
Simmons is my turn.
Although she's your attorney, would you be able to be fair to Mr. Clavel? Listen to the testimony. Would you be so partial to Hayden, I'm sorry, Ms. Simmons, to where you could not give the state a fair chance? So you can. Thank you. So that's what we're talking about. We just, again, no right or wrong answer, just looking for the candor. But okay, now, does anyone know myself, Cornelius Williams or Miss Farron Nixon?
I recognize you from church.
Yes, sir. We're gonna get out there.
We had a
and
conversation, but
yes, sir. Just meet and greeting, and we go to St. Anne's. Very involved in it within the community, very involved within the church. By you being also enough your involvement within the church. There's no way to actually this, excuse me. No way to actually this, Mr. Maines. Can you be fair to Mr. Clavel and the defense, as well as the state? From the nature and quality of our relationship, would you give any more weight to what I may say? Thank you very much. Now, I ask you all to look around. Does any member of the array know any other member of the array, the panel? I'm gonna take a guess how you guys know each other, but for the record, Mr. Eves, how do you know Mr. Maines?
Mr. Maines and I go to St. Anne's and Usher together.
Should you two gentlemen be deselected or selected, should you guys sit on a jury together? Given the nature and quality of your relationship by being members of the same parish, could you independently and collectively evaluate the facts of the case and the laws presented by the judge equally and independently?
Yes, sir.
I hope so.
Let's put it also another way. Once, should both of you guys sit on the jury? Ms. Eves, just for the record, your profession, you are an attorney.
Yes, sir.
Mr. Maines, should you sit on a jury with Mr. Eve, would you give more weight to his opinion or the way in which he views evidence because he is attorney and a member of the parish?
Unlikely.
So you can be fair independently and his influence won't overwhelm you. Ms. Eves, would Mr. Bates, influence, and what I mean by influence, the nature and quality of your relationship by being a member, for the record, by being a member of the same parish, should you guys sit on the same jury? Would his opinion, weigh more to you than anyone else's?
No, sir.
Thank you. Now, does anyone else on the panel know any other member? Thank you, Bobby. What we doing on time, Donna?
Okay. You have 17 more minutes.
Very good, thank you. Honor. Okay, the offensive theft involves several offenses. Several elements of the offense that the state must prove beyond a reasonable doubt. We must prove the following technologies, the following three elements. That the person appropriated the property of another. Now, remember, early on, we don't take things that don't belong to us. What does appropriate mean? They took the property. Was it their property to take? No, it wasn't their property to take, but the second element, that the appropriation taken was unlawful. I did not give you permission to take my toy. I did not give you permission to take X, Y, or Z. And the third element, that the person did this with intent to deprive the owner of the property. Once again, not to belittle or undermine, but I don't want our concept of justice or this entire trial process to be something ephemeral or something out there. It's real, it's practical. You don't take your neighbor's toy. Give you permission, you don't take it. But you know, ladies and gentlemen, the manner in which we also view the evidence, we have direct evidence. I saw Jimmy take the toy. Mom, I saw him. He took my toy. He went home. That's called direct evidence. When a person sees it, it could be recorded, which is direct evidence. I submit to you all right now that this case is a circumstantial evidence case. What do I mean by circumstantial evidence? Circumstantial is indirect evidence. Look, when we take a look at Dumpling, you guys go home. Dumpling is like a dog. Left Dumpling in the house, thought Dumpling was in the cage. Okay? You go home. Dumpling is out the cage. I go to him. I say, Dumpling, what did you do? Dumpling tore up a cushion of the sofa. What does Dumpling do? Because I'm kind of yelling at him. But then it's also they go, turn his head. Nobody else was in the house. Can you conclude beyond a reasonable doubt that Dumpling was the person, Dumpling was the entity that tore up the sofa? I ask you, Mr. Husky, can you find beyond a reasonable doubt that Dumpling was the one who tore up the sofa cushion? Thank you, Mr. Hussey. We're going to go down the line. Mrs. Powers, can you find beyond a reasonable doubt, although you didn't see it, you weren't there, no one else was in the home, You come home and Dumpling is looking at you like this and you see the cushion. Could you conclude beyond a reasonable doubt that Dumpling tore up the sofa cushion? Mr. Eves, can you conclude beyond a reasonable doubt? And ladies and gentlemen, the reason why I do this is to clearly establish like within the record, but I'm also seeing if someone may need more. Can you conclude beyond a reasonable doubt that Dumpling did that, or you would have had to see him to do it, to conclude beyond a reasonable doubt?
Were there no other dogs in the house?
No other dogs, you just have Dumpling.
Then I
No.
I can conclude that Dumpling did it.
Is it, Barnett?
Yes.
Okay. Now, Mr. Barnett, I also see that, you have served on a criminal jury before, correct?
Long time ago, yes, sir.
And did you guys reach a verdict?
Yes, sir.
And was there a punishment assessed? That's a yes or no. Okay, now. We will come back to beyond a reasonable doubt. But viewing the evidence, indirect evidence, circumstantial. You come home, you see this, you know there's no other dogs in the home. Can you conclude beyond a reasonable doubt that Dumpling tore up the cushion?
Yes, sir.
Thank you, Mr. Barnett. Got to get new glasses. Mr. LaFourte. Same question to you. Or can you conclude beyond a reasonable doubt, once you get home? You see the cushion tore up. No one else was in the home, no other dogs, in the house. Although you didn't see the dog do it, can you conclude beyond a reasonable doubt that Dumpling did it? I think it would be very likely. Once again, no wrong answers there, Mr. LaFourte. You said, very likely. The court cannot, well, not cannot, and also will not, define for you what is reasonable doubt. Would you have a reasonable doubt that Dumpling did it, or would you have needed direct evidence? Nothing. Mr. David, how you doing this afternoon? Would you be able to conclude beyond a reasonable doubt, although you didn't see it, but you see the circumstances which implies that Dumpling did it? Could you conclude beyond a reasonable doubt that he in fact did it? Ma'am?
Yes.
Thank you.
We have 10 more minutes.
Thank you, Your Honor. Okay, let me move on. Mrs. Wooten?
Yes, sir.
Good afternoon, ma'am. Would you need to have seen it? Would you need direct evidence to conclude? Well, I didn't see Dumpling do it. I didn't see him do it. Maybe somebody else broke into the house, tore it up, and then kind of blamed it on Dumpling. Or can you look at the circumstantial evidence and conclude that Dumpling tore up the cushion, although you didn't see it?
There's no other dogs in the house, Dumpling did it.
Okay. Mr. Munoz Martinez, good afternoon. How you doing?
Fine, sir.
Good, good. Now, Mr. Munoz Martinez, you're an engineer, correct?
Sir.
Would you need direct evidence to put everything together, either to have seen it, to conclude that Dumpling did it, to the exclusion of all other reasonable doubt? Let me slow down. Or by coming home, and you see this, you see the cushion, can you conclude beyond a reasonable doubt that Dumpling did it?
Yes, sir.
Thank you. Mr. Cantor?
Beyond all doubt, no. Because going in and looking at that, judging him guilty immediately robs him of his due process.
Does any other member of the array agree with Mr. Kenter on the statement he just made? That coming home, okay? We have, okay, Mr. LaFord? What about a statement that you agree with that, Mr. Kenter's, state?
I mean, not doing anything about this dog and like, the doors are open and, you know, I mean, I just don't know enough to make it.
Other hand, I saw, okay, you're number 19, that's, Ms. Bean?
Roadshow.
Okay, Mr. Rocho, do apologize, I see you there. What more evidence would you need that Dumpling did it? Would you have to have seen it yourself?
I would just say that I needed more direct evidence because that's just my brain is going to, I don't know what was open. Doors that were open, so it just seems like I just couldn't go off of just one piece of circumstantial evidence. That's just how my brain is working without it.
Fair enough. And Ms. Madrano? Madrano?
Well, I'm a nurse and in nursing, we're taught to never assume. Cause you take the word assume and you break into three more words and you don't ever want to be in the position of a nurse. So, if I didn't see it actually happen. I don't know what transpired in the time that I wasn't there, so I couldn't say for sure that yes, the dog did it.
You are a, nurse, correct? And you work at, is it a convalescent home?
No,
No,
no, I work for Harbor Hospice.
okay, okay. If, you're visiting a patient and although you weren't there, if the patient either have, okay, hospice care, a broken bone, okay, or if they're bedridden or bed sores, although you did not see that, can you be able to conclude, and that would be through circumstantial evidence, that the person, developed again bed sores because the person wasn't being properly, rotated or put from side to side, correct? Although you didn't see it. Would you agree with that?
I would have to chart likely due to, because I again did not see it.
Yes, ma'am. Okay,
Maybe 5 minutes.
thank you, Your Honor. Ms. Victoria.
I mean, as long as there's no other animals and there's no like open windows or doors, then I assume the dog did it.
And could you, could you assume beyond a reasonable doubt? Now, again, the state has a burden, which we welcome, the state welcomes the burden. We have to establish each and every element that we touched on before beyond a reasonable doubt, beyond a reasonable doubt. Not to the exclusion of all doubt, but what is reasonable? Okay, so can you look at circumstantial, we excluded all what unreasonable doubt, if that's excluded, can you so conclude, through circumstantial evidence that Dumpling did it beyond a reasonable doubt?
Yeah.
Ms. Mannings.
Just looking at that picture, the dog has an expression on its face. Like this is not the first time it's torn into a cushion. So I would assume, given the circumstances you provided, that Dumpling is charged with the kind of solving the pillow.
I have never, quite heard it like that, but thank you for sharing that. Ms. Fitz.
Your doggy door?
Oh, great question.
Animal coming out I have one, that's one house. I've had some come in my house, so. If you don't, then.
Having, if, even let's say you have a doggy door. You still come home, you still see Dumpling next to like the cushion. Would you conclude that beyond a reasonable doubt, or would you think a raccoon or another dog got in?
Oh, I would think squirrel in my house.
Who said about the cat? That was funny. It could be a cat. That's Mr. Landry? They said it could be a cat. Once again, you guys are really great. I didn't think about that. It could be a cat. Finally, let us just touch on, Mr. Bean. Could you conclude beyond a reasonable doubt that Dumpin had actually done the offense of assaulting a pillow? And Ms. Jacka, can you so conclude? Now, again, everything that we touched on had to deal with. I'm sorry, for someone. Okay. What we had touched on, again, is not by preponderance of the evidence. We talk about our burden of proof, which the state welcome. That's what we're talking about. If we can establish beyond a reasonable doubt, and again, beyond excluding all other doubts, all other reasonable doubts. Okay, we can't say that maybe okay, an alien came down, they do it. Well, ladies and gentlemen, I'll submit to you, I'll place before you. That's just not reasonable. Who may have taken an item. Once again, we learn all of this in kindergarten. It's up to you to decide whether the evidence is proven beyond a reasonable doubt. It's up to you. You will be the sole judges of the facts of the case, and the facts will come from the witness stand, from the witnesses and the evidence presented. The judge will give you the law of the case, and you will apply the law to the facts and come up with a conclusion. Once again, it's reasonable doubt, not all doubt. Now, is for any reason that any person cannot serve on the pettit jury, should they be selected for religious reasons or otherwise? And what I mean by for religious reasons, does anyone think that within our community, no person should judge another person based on their religious beliefs? That would be your Ms. Baracho.
Yes, sir.
What is it that you don't think that a person should sit in judgment of another person?
Well, I don't believe in that. I believe that the Lord is the only judge. I do believe in the law, but I'm in a so it's a little challenging for me to, I would say, evaluate it in that way. Because I just don't feel qualified to be a judge.
Thank you for your candidate once again. Thank you. We expect a trial, those selected a jury today. We expect the we expect the trial to go Tuesday afternoon from roughly 1:30, maybe to 5, and then maybe also onto Wednesday. Does anyone have a scheduling conflict where they cannot be able to attend? Mr. Eves, yes, sir.
I know everyone's busy. I have a deposition tomorrow. I have a full day mediation on Wednesday and full day mediation Friday. Be tough to reschedule. So that's good. That put me in a bind.
I did, yes, sir, I understood. Yes, sir, Mr. Hudson.
No possible way it's going into next week, right?
I cannot fathom that, no, sir. No, sir. But thank you once again. Does anyone else may have like a doctor's appointment or anything that they can't get like a change? Kids or, yes, ma'am.
I have a mandatory training after on Wednesday.
Okay, Ms. Victoria, let's see, training on Wednesday. Anyone else? Yes, ma'am. Ms. Groggs?
Yes,
Yes, ma'am.
I just have to work on Wednesday. I took off tomorrow, but not Wednesday.
Thank you, ma'am. Anyone else?
And we use work
Okay.
as an excuse.
I'm sorry.
And we use work as an excuse. I work with call 365, so.
Actually, as the judge said, work or economic, it's not an excuse, it's not an excuse. But so noted. Okay. Thank you for your time, your attention, and answering the questions again truthfully. Should you all get chosen, I will, in the book, we will hold you all to account. Again, what I'm saying to account, again, for you all truthful answers. We can do better. Thank you.
Okay, Mr. Williams, you used 33 minutes, so Ms. Delage, you have 33 minutes.
Good afternoon, everybody. I'm alive. I'm Jennifer Delage. I am here as the defense attorney today. I want to talk about gunplay for a second, since we brought gunplay into the picture. I also have a dog. He's much better behaved now because he's a golden retriever, and that first 2 years is not fun. Okay, but I also have kids, had cats, other animals can exist. There was a few of you that answered that you could find him guilty based on the circumstantial evidence of the picture. Which would also be finding him guilty without due process. We are all guaranteed due process. And when the picture came up, I'm thinking, and I like to know the comments, cat. I had written down cats, I had written down doggy door, but I had not written down some squirrels and other like that. I do have kids and things can happen. Okay, so who here, based on that, right now would vote for my client as not guilty? Who here would vote my client guilty? All the right answers. Who would say that you don't have enough information yet to make that decision? Good, thank you, everybody. All right, one of the things that's really important, have you heard this statement? And I'm gonna leave a blank in there and I want y'all to tell me what it is. Innocent, blank, proven guilty. Guess who has the right answer? Mr. Oh, it's hard when you're up here to get the right name, Mr. Mays. That's correct, it's unless, I mean, we hear all the time innocent until proven guilty, but that's just not true. It's innocent unless proven guilty. And that is because the state has the burden of proof. They have to put on an entire case. And my client doesn't have to put on anyone. Does anybody here feel like if my client were to testify that that would mean he was guilty? So everybody understands that he has the right to testify or not to testify, right? Okay. So did anyone walk in here and see my client and think, I wonder what he did? No. I also like to ask, who, other than my client, doesn't really want to be here right now? Yeah, I imagine there's a few of you. I mean, I'm excited, this is what I do, but I mean, not everybody sees you, right? Because the defendant sitting here is charged with something, does that in your mind, any of you put in your mind that he had to have done something? No. Do any of you believe that the defendant needs to present evidence to prove his innocence? That's again the right answer. It's on the state to put on all of the evidence. The defense can or cannot present a case, depending on what is proven or articulated by the prosecution. So obviously we're talking about theft here, and we talked about some of the elements. And the first two are pretty clear. There has to be a taking and it has to be unlawful, right? That third one though, that one can get confusing. You understand that the defendant in a theft case has to have formed the intent to take to the unlawful taking. They have to have had intended to do so. Everybody understand that? Yeah. Okay. So with that being said, have you, any of you ever been a victim of theft? Tell me about it, Mr. B.
Oh, there was a guy that did some work at my house and, paid him and, the amount that added will give us to and cashed it. And, no.
How'd that work out for him?
For him, I don't know if he was ever caught.
Interesting.
Yeah.
Okay. And how does that make you feel?
I would make anyone feel.
Well, agreed. Do you think that because you have been a victim of theft that was not answered, that you would have bias in this case?
No,
Do you think it would affect your decision on whether you think my client is guilty or innocent?
no.
Thank you. Who else raised their hand? Want to go back with you, Ms. Scroggs?
I used to work in the service industry as a server or bartender, so I've had plenty of people that walked out without paying their bill, whether it's cash.
Sure, and what happens when that happens?
I have to pay it.
Right, and so, do you think you've had any bias, or have a hard time, not holding that bias when deciding if my client is innocent? No. And I'll share with you this, as far as bias goes, so we all understand it. I was speaking with my client and my co-counsel earlier, and I was thinking, geez, I know a little about hair day. And then who's on the panel? They're all so please don't judge my hair, it's not doing the best. Please don't judge my client based on my hair.
No.
Okay, who else raised their hand with that? All right, let's go with you, Miss Medrona.
Was broken into some years ago, they stole good things, and we never knew who it was.
Never got any closure on that. Do you think that would affect how you decide my client is guilty or innocent? Okay. And Ms. Wooten, how about you?
Yes, had my purse stolen, money stolen out of my purse. I've had things taken from my daughter's grave at the cemetery, so yeah, lots of, yeah. People are crooked.
People are, some people are, that is true. Did you ever get any closure on any of those?
I got my purse back, believe it or not with any money in it, but
Stalker.
yeah, they put it in the
That's
mailbox.
surprising. Well, was the person found that did that?
No.
And do you think, having been through those situations, especially the grave robbery, I never done that, that would affect your decision in determining if my client is guilty or innocent? Okay, thank you. Who else over here? I think I got everybody over here. Yes, ma'am, Miss Jocko, am I saying that right? And if I butcher, Jacob, please tell me if I butcher names. My last name is DeLage. People say DeLodge, DeLedge. I really don't care, it's my husband's name, but it's so anyways, I'm sorry if I butcher it, but. So what happened with you, Miss Jacob?
I had my car broken into and my purse was stolen. Never got it back. Knew who did it. Nothing was done.
Nothing. Do you think that that would affect your decision in determining if the client is guilty? Thank you for that. Anybody else that I missed? No? All right, see, what about family members? And I don't want to go way down the line, but I mean, I'm talking about a spouse or something that was be close to you that had a theft occur. Yes, sir.
My in-laws,
Okay, what happened to them?
somebody broke into their house and took some things.
And did they ever find out who it was? Do you think that that would influence your decision in determining our client's guilt or innocent?
No.
Okay, thank you. Anybody else with something similar? All right. So is there anyone who feels like that any accusation of theft deserves jail time? Just because it's a theft, does that mean someone should get jail time? All right. Regardless of circumstances, obviously. Do you think that any of you or all of you could consider the full range of punishment, which means anything from probation or a fine all the way up to the 2 years that Mr. Williams discussed? What was that? No, everybody thinks they could consider the full range of punishment? All right, so this kind of goes back to dumpling, but, and I'm loving dumpling's name, I'm just gonna use it all the time. But if you yourself found yourself accused of a crime, would you want jurors to wait until they heard the full case before determining if to making a decision? Or would you want them to look at you and say, no, they said, the state says he did it, he did it. Everybody thinks they could do the right thing there. Speaking of which, has anyone ever been accused of a crime they didn't commit? No, yes, I thought you were shaking your head, sorry. Yeah. All right, this is an interesting question because I mentioned that the state has the burden and it's beyond a reasonable doubt, which is a pretty significant burden. I know we've got a civil attorney over here, their burden is a lot less, so it looks a little different. But this means it's not beyond any doubt, it's beyond a reasonable doubt. So just like dumpling, some of us couldn't find dumpling based on that photo, guilty. Because while we might think there's evidence to support dumpling having committed that crime, assault of a pillow, I believe is what we label it. But there's not, that we don't have direct evidence to show that, right? And so, yes, someone can be found guilty because a jury decides based on circumstantial evidence. But you do understand that the state has to prove this beyond a reasonable doubt. All right, so what that means is, just like in this 4-hour, I'm not gonna have as many questions with the state. In the presentation, I'm going to cross-examine the state's witnesses, but I may not put on any witnesses myself. Because again, it is on the state to prove that something occurred, not on my client to prove he didn't do something. Okay, everybody understand that? Everybody good with that? All right. Okay, I'm gonna give you a little scenario. My friend over here, Mr. Maines, you just became my target today. So you said in one of your responses, and it was quite innocent, but you said, I think I can, or I think I can be impartial. I think you're half joking, you know, with Mr. Williams since he has attended your church, right? Okay. Well, I want y'all to picture this. Say you're on a plane. You got a pilot, and you ask the pilot, can you land the plane? If the pilot says, I think I can, how do we feel about getting on that plane? We don't feel real good about that, do we? So I guess my point is I want to make sure everybody really does feel like they can be unbiased and impartial. Anybody have a problem with that? Okay, another little scenario for you. And it used to be different. People used to actually watch the news on TV, but now we all know where we get our news and it's sitting right there on the table with the telephone, right? So say you're reading, scrolling through your phone and you see two different news cases. One of the cases, the person committed a crime, but got away with it based on a technicality. The second case that comes up, the person served time in prison and was later found to be innocent. Which one of those stories upsets you more? All right, I'm gonna call on some of y'all. Ms. Madrano, you look like you wanted to answer.
I'm gonna say the latter, cause that person went to jail for something that he didn't need to go to jail for.
Agree. How about you, Mr. Landry? I can't hardly see you back there. What do you think?
Ladder.
The latter? Yes, sir, me too. Ms. Wooten, what do you think?
Same.
All right. Anybody have a different, take? I'm always up for a little banter. No. All right. All right, so. Kind of lastly, and again, I told y'all I'm not gonna take as much time as Mr. Williams I could hear. But if you believe that my client committed this crime, but that Mr. Williams did not prove it beyond a reasonable doubt, can you acquit him? I'm gonna think about it. You think you could acquit him anyway, just because you believe it? Even though you don't think it was beyond reasonable doubt? Well, I won't call on y'all individually on this one, but it's something to think about. Lastly, I just want to say thank y'all for being here. We appreciate it. We really appreciate it. We couldn't do this without people sitting here. I myself have been on jury duty in the last 3 months, so we all take our turn to do it, and I know that there's other commitments out there, but we just appreciate being here. Thank you. Wait, you're on.
Okay, thank you, Mr. Davis. Okay, ladies and gentlemen of the jury, at this time, we're gonna ask that you go out into the hallway. You could go out either door. We may call some of you back in for some follow-up questions. So at this time, everyone please stand as the panel exit the jury, as the panel exits the court. Vic, take either door.
I have to go, they're both open. Here, hold on. What?
Ready.
Make sure I don't.
I'm good.
Y'all could be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M331246, case of style of the state of Texas versus Dallas Lavelle Jr. Let the record reflect that Mr. Lavelle is present in court with his attorneys, Attorney Jennifer DeLedge and Attorney Haley Simmons. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams and Attorney Farrah Nixon. Let the record also reflect that the panel is now present and seated in the courtroom. Ladies and gentlemen of the panel, when your name is called, please go to the jury box. And when you go to the jury box, you'll see some black tags, name tags on the counter. You can take one and have a seat in the jury box. Okay. At this time, we'll have which one is going? Miss Glenda Segura, who will be calling those names. Miss Segura?
Yashika Powers,
Yashika Powers,
Dale Barnett, Judy Wooten, England, Lindsay Victorian, Stacy Fitz, Anaya Bean, Marla Jacob.
okay, everyone, you could pin the name tags on. Okay, ladies and gentlemen of the jury, I need each and every one of you to raise your right hand. I will administer to you the second of the 2 oaths. Please raise your right hand. Do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Dallas Lavelle Jr., you will a true verdict render according to the law and the evidence, so help you God? Please say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from statutes, codes, rules, and other court decisions interpreting them, and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts. You receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper, on social media, or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The name tags that you have, please wear those name tags at all times because those name tags identify you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who were not selected, first of all, I'd like to thank you for taking time out from your busy schedules to come here this afternoon. I know some of you may feel disappointed because you were not selected. In our system in the county court at law, and even in a district court, you only have a limited number of people who can serve on the jury. Now, I do not want you to think that you wasted your time because you did not waste your time. And the reason why I say that is because, as I mentioned to you earlier, we had 3 dockets and we had up to 50 people. total on those dockets. And the reason why I'm saying that is because a lot of times, when people are charged with offenses, the state usually get with the attorney to make an offer to settle the case. And sometimes people say, well, you know what? I'm not going to accept that offer because I believe one or two things may happen. One, they may believe, some people believe for some reason that the jury is not going to show up. Or two, they may believe that, well, witnesses are not going to show up. But on days like today, when jurors and witnesses do show up, it is not uncommon for some individuals to have a change of heart. That is, they say to themselves, you know what? An offer that the state made to me a few months ago, it looks pretty good right now. Said that to say this. It's because of people like you who took time out from your busy schedule, you helped us to move cases just by your presence. And so you did not waste your time. Now, I know that when you came to court this afternoon, you probably looked over the door and you say, oh, this is County Court at Law Number 2, Judge Holmes Court. I'm in the right place. Well, you're in the right place, but this is not Judge Holmes Court. This is your court. This court is for the citizens of Jefferson County. You're a citizen of Jefferson County. This is your court. I've said that to say this. Anytime that you're in the area of County Court at Law Number 2, you can have a seat in your courtroom. In fact, you could sit in the same area that you're sitting in. We call that the peanut gallery. But you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and just see what goes on in Jefferson County. I know that you'll find it very interesting. Now, the bailiff have some letters for you all. She's going to give each and every one of you some letters. And if you feel like dropping us a line, you can. Now, before you leave, I need to tell you that, well, it's 4:30. If you need an excuse, we'll be able to give you an excuse here. Normally, the district clerk will be able to do it, but they close at 4:30. And so if you need an excuse, just let us know and we'll be happy to have our coordinators to give you the excuse that you need. But before you leave, I usually give everyone a handshake normally, but you know, we still have COVID in our community. However, I still can give you a handshake. I call it an air handshake. So on behalf of the staff here in County Court at Law Number 2, I like to shake each and every one of your hand. And thanks for coming out today. And you are excused. And as I mentioned to you earlier, the bailiff have letters for you, and every one of you had a blessed day. If you want to, our trial is going to start back up at 1:30 on tomorrow. If you want, you could come have a seat in the gallery, or you can watch us on YouTube. Everyone has a blessed day. And see you later, Attorney Eves.
Thank you, John.
All right, you have a blessed day.
Thank you for being here.
Thank you, Spain. No, I'll do no work.
Okay, ladies and gentlemen of the jury, as I mentioned to you earlier, to everyone earlier, our trial will start back up at 1:30 on tomorrow. So when you come, try to get here a little early. You're gonna have a seat in the hallway, and then when we're ready for you to come in, the bailiff will come out and get you. Okay. So at this time, the court will be in recess. Everyone, please stand as the jury exits the courtroom. And y'all have a blessed day. Yeah, y'all keep the tags and just wear them with y'all when y'all come back.
You losing my tag already, sir?
Okay, the court will be in recess till 1:30 tomorrow for trial.